Hey, good morning, everybody. I imagine people are going to keep trickling in for the next few minutes, but we'll go ahead and get started. I'm glad you guys are here. My name is Paula Whitaker. I'm with Hawaii Autism Foundation, and today's topic is on long-term planning. This is something my family is currently involved in, long-term planning, so it's very relevant to me. And as we talk to more parents, we realize this is something that's very important to most people and something that can be a little overwhelming and not sure exactly where to start. And so we're thankful for our experts who are here today to help us. I do want to remind you that this meeting is recorded and it will be available online on our website, and it will also be emailed to you at the end of this meeting. I'll email it either tonight or tomorrow morning, and I'll also email you any sort of resources that were mentioned during the meeting, so you'll have access to all of that. I've got your submitted questions. If you submitted a question, we've got it, and I will be sharing those with our experts today. If you think of an additional question that we're not covering, you're welcome to add that in the chat, and we'll try to circle back to it. And I want to point out that even though we do have an attorney as one of our expert panelists today, that the content that is mentioned today is meant to be informational and not to be taken as legal advice. So now with that, I'd like to introduce our expert panelists. First up, we have Mr. Scott Suzuki. Scott, hi to everyone.
Hi, everyone.
Scott is a local attorney who specializes in this sort of thing. I'll let him tell you a little bit more about himself in just a minute. And then we also have Susan Rocco. Susan, you want to say hello? Susan, Susan's a parent of a special needs child in addition to working in the community, and she has some experience with this and to be sharing her experiences with us. So with that, we will get started, and thank you all for being here. Scott, I'm just going to start with the first question. So the first question we had is, what is the difference between guardianship, conservatorship, and power of attorney?
Okay. Well, again, thanks everybody for having me here and for participating in this unusual Zoom conference call. I know these are interesting times, but I'll try to cover all the questions as quickly as I can, and if we need to circle back on any of the topics, I'm happy to do that. But let me start with the guardianship. What is a guardianship? Guardianship is a court proceeding in which the judge will determine that a person is unable to make decisions and take certain actions on his or her own behalf. And then the court will appoint somebody called a guardian to be able to make those decisions. Those decisions exclude finances. The conservatorship is basically the same process, but it is for financial purposes, where the court will appoint somebody to be able to do business transactions, financial transactions, real estate transactions on behalf of somebody who cannot do that on his or her own behalf. Both the guardianship and the conservatorship are the court proceedings, and the alternatives to that would be the documents like the power of attorney or the healthcare directive. The power of attorney and healthcare directive are documents that an individual would sign to authorize somebody else to act on his or her own behalf. The difference between the two is if you need a guardianship or a conservatorship, it means you're unable to make legal decisions on your own. So you would not be able to sign a power of attorney or a healthcare directive. The power of attorney or healthcare directive means that the individual understands what they're signing, they understand the implications of what they're signing. And if they don't, then we can't do a power of attorney or a healthcare directive. That's my nutshell response. Oh, I'm sorry, you're muted.
Can you explain the circumstances where someone might need to think about guardianship? Like what are the circumstances that would make someone say, this is something I might need to pursue?
Okay. There are a lot of different types of guardianship, so it's important to note that it's not necessarily a one-size-fits-all situation. There are guardianships for minors, and there are guardianships for incapacitated adults. Those are the two big different categories. A minor who has legal parents who are able to assist him or her does not need a guardianship. Parents are natural guardians of their minor children. So unless the parent is maybe sick or deployed, something else has happened that that parent can't help their child, a minor child doesn't need a guardian. They already have one in the form of a parent. For a person who's over the age of 18, who is unable to make decisions on his own or her own behalf, that's when we would need the guardianship. So the person is going to be unable to sign the power of attorney or sign the healthcare directive and is over the age of 18. That would be the main trigger that the courts are looking for to determine whether a guardianship is needed.
Okay, we had a question too about appointing co-guardians. I know that sometimes if both parents are alive and have, they might have co-guardianship of an adult child. For single parents, is there any benefit to appointing a co-guardian or?
The benefits of co-guardianship, I think it's important to consider different options. I like to have a backup plan because people are people, they're humans. They can get sick, they need time off, they need to go on a vacation. And sometimes just having somebody else who can help out is a good idea. You need to make sure that all of the guardians are really on the same page philosophically. They believe that the answers to the questions are the same answers to the same questions. They're not completely adverse to each other. I mean, it's okay to have difference of opinion, but ideally the guardians would see eye to eye with each other. I do like to have the co-guardianship in most circumstances just to have that backup, but I also like to build into the order that the co-guardians are authorized to act independently of each other. That way, if somebody is just on vacation, we don't have to track them down just to be able to consent to a medical treatment, for example. I also like to have co-guardianships when we're thinking about transition planning. And transition planning is becoming more and more common. As parents get older, maybe they're in their 80s or their 90s and they're trying to think, what's next for my adult child? Maybe they bring on a sibling as a co-guardian, and they can have a period of time where they're training them to figure out what's the best course of action. How are we going to have some continuity here as I maybe transition out of my guardianship roles? So there are a lot of benefits to having co-guardianship. As long as the guardians do see eye to eye, I don't really see a downside in having multiple people serving as guardians.
Okay, thank you. The next question is, what rights are given up by my child when we establish guardianship or power of attorney or conservatorship, any of those situations? What rights does the child give up?
Okay, I kind of have a love-hate relationship with this question. It is a question that I get very frequently. And I love it because it gives me the opportunity to try to dispel some myths about guardianship and the need for them and the process for them. And I hate it because it is clear to me that there still is a lot of misunderstanding about what guardianship is for and its purpose and its intentions. So my perspective on guardianship is that we are not taking away rights from anyone. What we're doing is we're actually adding rights. We're adding rights to the guardian to be able to make decisions for somebody who might need assistance with it. The Hawaii law was changed in about 2005, maybe about 2004, but went into effect in 2005. And one of the purposes of those changes was to make it clear that the guardian is only needed to exercise their rights on behalf of somebody who cannot exercise their own rights. So if you can't exercise your own rights, you're not really losing any rights. What you're doing is you're having somebody in place with the legal authority to exercise those rights on your behalf. It really is the concept of adding authority. You're adding it to the guardian, but you're not necessarily taking away rights from anybody. There are some exceptions to that rule, but that is really the big picture that we want to try to get across, that we're not trying to limit anybody's ability to be autonomous, to act independently. We're trying to add a layer of protection and assistance. And some of those exceptions might be voting comes to mind. If you're legally incapacitated, then they're not going to allow certain voting rights. You can try to limit the guardianship to determine that the person will retain their ability to vote. But I think that's a really difficult thing to do. And I'm just giving a big example. But I do think that's really difficult, that the court might say, well, you can't make a medical decision, but you can still pick a particular candidate. Who knows what comes along with that, but those are very much more difficult questions than just blanket terms. Are we taking things away, or are we adding rights? And again, the philosophy that I want to make sure everybody understands is that we're really trying to assist people in their autonomy, to preserve as much power and authority as they have, but then add a layer of protection to that, where there's a guardian who can always serve as a safety net.
Okay, thank you, Scott. If someone has decided that this might be something they need to pursue, that this is the right decision for their family, what are the steps that need to be taken to establish guardianship?
The general steps for guardianship, and I'll just do this in a nutshell, and maybe Ms. Rocco is going to go into this in a little bit more detail in a couple of minutes here. But what you have to do is be able to prove to the court that the individual needs a guardian. And you need to be able to prove to the court that the proposed guardians are the most appropriate people to do that. So what we normally would counsel people to do is at about age 17 and a half or so, get in touch with whoever's going to help you, or if you're going to do it on your own, get the information that you need. We like to have a birth certificate because we need to prove that the individual is over the age of 18. Otherwise, it's a different type of guardianship, guardian for a minor. So 18, birth certificate. Then we would like to have an opinion letter from the individual's physician or psychiatrist that will attest to the court that the individual does need the assistance, that they are unable to exercise certain rights of their own. And that's the standard of proof that we need. Then you file a petition with the court. The petition tells the court that this individual needs help and that the proposed guardians are the best people to be able to help out. Once the court receives the petition, the court will assign a hearing date. That hearing date is when the parties go to court and the judge will ask questions and make sure that everything matches up with the letter of the law. Once the hearing date is fixed, then we have to serve parties, which means we have to give them the information about the hearing. That way they can come in and either support the petition or make their concerns about the petition known. So maybe they're going to object, or there are other questions about the petition. Then it's just a waiting time. Once everybody is served, you just wait for the hearing. Then you go to the court, have the hearing, and usually at the hearing, the judge will be able to make a decision, approve it or deny it, and grant somebody the authority to serve as the guardian. From that point, you have 30 days to file an initial guardianship report, which more or less is a form that you fill out. And then once a year, you file an annual report with the family court. And again, it's just a form you fill out, and you let the court know whether the guardianship should continue or if it needs to be modified in any way.
Okay, I know that it varies a lot from depending on who you work with or different situations, but can you ballpark some of the costs involved for guardianship? For
yeah. Sure. Guardianship petitions, it really depends on if they're going to be contested, which means people are fighting over it in any respect, and people can fight over really anything, unfortunately. So if it's going to be contested, then there's really no way to estimate it. But if it is uncontested, our office normally charges about $3,500 as a flat rate, and there are fees included with that, which would include the court fee. You have to pay the court to be heard. And there's a process server fee. You have to pay somebody to professionally go and hand deliver all of the paperwork, the mailing costs and whatnot. But all of the petitions, the legal work, the representation in court, the appearance in court, and assistance following that with the annual report or the initial reports all included in that. So I would guess that going rates in town are probably from about $3,000 to $10,000, which is a huge window. I know our office would be able to usually quote a flat rate though from the beginning. And usually it's around $3,000 to $3,500.
Thank you. Do you have to have an attorney to get guardianship for your child? Is it possible
No,
in the court, you know, if you knew enough about it?
Sure. Yeah, it's definitely possible for you to represent yourself in court. That's always an option in really in any proceeding. Some people are great at it and they really enjoy it and they like the process and it's a good experience for them. Some people hate it. I kind of view it in terms of, or I compare it to maybe filing your tax returns. You can file your own tax returns if you want to, and some people just like to hire an accountant to be able to help them to do it. Either way, it's fine. I would suggest though, if it's something that's new or if it's something that is maybe intimidating, having some legal representation would be very helpful. If you think that it might be contested where people are going to fight over it, it's probably more important for you to have an attorney help you out with it, just because of what's at stake. If you try it on your own and lose, that could be, unfortunately, more consequences down the line. But it's absolutely possible to do it all on your own if you like to.
Okay, we had a question come up on the chat, Scott. If a parent has gone through guardianship already, that's been approved and they're done, do they need to bring that paperwork with them anytime that they're making a decision for their child?
I would say generally yes, they should take the documents. What I'm guessing is that the individual is referring to the guardianship order. There's an order that's signed by the judge, and that order is the proof that the guardian has the legal authority to act on the individual's behalf. Without that proof, the people that you're working with, and that might be the doctor's office or social services or public benefit agencies, they're not going to know that you're the guardian. They might take your word for it, but in this day and age, it would be rare for people to just accept the word of honest people, unfortunately. They need to have something. And that order is really the document that is going to prove that you have the ability to be able to help the person that you're assisting.
Thank you. Switching from guardianship over to sort of the financial part for a minute, what steps do you suggest that parents who might have teenage children with disabilities should take now to start thinking about financial repercussions for adulthood?
Oh, great question and very complicated question. A lot of parts to it. So I'll try to boil it down as much as we can. But if you are trying to do some planning for a loved one who's maybe a teenager and you're thinking about transitions, those transitions might be from minority to adulthood or from Department of Education services to adult day programs or other care programs working, for instance. There are a lot of considerations that you would need to have. One thing that you would want to consider is whether guardianship is appropriate or maybe a power of attorney or a healthcare directive. That timeline would be about age 18. Right? You cannot sign a power of attorney or a healthcare directive before you're 18. So that would be one thing to think about. I like to think about long-term planning because we can get really focused on the main issue that we see right in front of our faces, but there might be 15 more concerns that we can address in the future. I think a really good option for people to think about would be, is life insurance right for me? Am I gonna need to leave money for my loved one in the future? Obviously, the earlier you buy life insurance, the lower the cost could potentially be. I don't sell insurance, so I'm not trying to make a commission or anything like that. But life insurance can be a very, very valuable tool for people in the future. And public benefits is a good idea to start to consider too. Benefits would include things like Medicaid or SSI. the supplemental security income. Those are the two big programs that come to mind. And usually when a person is a minor, they're under the age of 18, their parents' income and assets are going to be used to determine if they're eligible. But after the individual reaches a certain age of majority, 18 or 19 or out of school, 22, whatever it may be, then that individual can qualify for those benefits on his or her own, and they can be extremely valuable. Understanding how those programs work can be even more valuable. Oftentimes, we have people that come in and they say, well, I applied for SSI when my child was 9 and the benefits were denied, so I know forever I can't get those benefits. That's not the case. The different ages have different rules. So if you were denied previously, you might want to reconsider applying again in the future. The other thing that I see commonly with the public benefits is for SSI, it's a really complicated program. SSI is based on your need, which includes your ability to work. And if you're unable to work, then you might qualify for these benefits. And to qualify, your income and your assets have to be below a certain threshold. The $2,000 threshold relates to assets only. We have to make sure that the assets are below $2,000 as of the date of application. This is important because a lot of families will start to save for their children. Maybe they got 529 plans for educational purposes, or maybe there were birthday gifts that have accumulated over 18 years. And if those amounts exceed $2,000, we need to have a plan of what we're going to do to protect them so that we can have those private funds to help to supplement the benefits that we're going to get from SSI. So we evaluate the assets that people have saved up. The third part of SSI eligibility, so we have our need, right, our work ability, our asset test, and then there's the income test. Income is really complicated because there's different definitions of income. Income could be money that you're earning from work, from wages. It could be unearned income that maybe you're getting in the form of interest on a bank account, or gifts, or an allowance that you're giving to your 19-year-old child. But income can also include food and shelter. And what that means in a nutshell is if you're paying for food or you're not charging rent to your adult child, Social Security, the SSI program, will reduce your benefits by about 1/3 of the federal benefit rate. That's approximately $250 a month. And if you just charge your adult child a little bit to cover the food or the cost of rent, you're going to get another $250 or so from the government that you can use for your child. That's a really important factor that you need to understand, because we want to make this individual's quality of life as good as possible. Whether or not money is going to do that is another story, but I think every penny can help. On top of that, so if we get our public benefits in order, on top of that, then you need to figure out what are you going to do with that money? Because a lot of parents don't feel comfortable charging their child for rent or for food. And eventually, if they're just saving it, they're using it for them, we need to make sure that we have a consistent plan in place to make sure that if I passed away or if something happened to me, that money is still available for my child. And that could be estate planning for yourselves, maybe making a will or a revocable living trust, or maybe making another planning tool available for your child. That could be a special needs trust. It could be an ABLE account. It could be an annuity. There's a lot of different options. No one size fits all. But those would be the types of things that you would want to start planning for as your child reaches their teenage years. That would be a good time to start really, really considering which of these issues are important for you to address. That wasn't a nutshell answer. That was way too long. I'm sorry.
It's a lot of information and it's a lot to process. And that was helpful. I did have a question. You mentioned life insurance. If something happens to me and I had life insurance and that money goes to my child with a disability, does something need to be done, or what needs to be done to keep that from affecting the amount of Social Security disability he is receiving?
Very, very good question. And these are details that you really want to flesh out because every case is going to be slightly different, right? Not every estate's going to look the same. Not everybody's going to have the same goals or objectives for their children. I use the life insurance example because I think it's a relatable concept that most people understand and can address. It's usually tax-free. But when you're dealing with what I refer to as a special needs planning situation, if we leave cash to somebody who's unable to manage cash, that's a bad thing. That could be potentially harmful. They could lose their public benefits. They could lose their housing. They could lose their medical insurance. They could get taken advantage of. They could lose it. A lot of scary things could happen. The better idea would be to leave that money in a way that we know it's protected. One common example of that would be to designate a special needs trust as the beneficiary. And the way this works is you are the owner of the insurance policy yourself. You're the insured life. So when you pass away, the insurance company will write a check to the special needs trust. The trustee will use that money for the benefit of your child. It won't impact their public benefits. It will be protected so that it's a lot harder for people to come in and steal it or take advantage. And we have a lot more continuity in the overall planning. Why did I choose life insurance as an example again? Some people will have other assets in their estate, for example, a home, real property, or a retirement account like an IRA. And those are still really nice assets to leave to somebody. Of course, we're not going to look a gift horse in the mouth and be upset about anything that's free, but there are different implications. Life insurance is just cash. It's the easiest thing for a trustee to manage. Real estate comes with other issues like how are we going to pay the taxes? How are we going to maintain this property? Is it too much house for the particular individual? So there's a lot more thinking that is involved with it. An IRA or a 401k, a tax deferred type plan, can also have its own challenges where these funds, we still owe taxes on them. So we're going to have to pay a tax on this before we can use the money. And that can add another layer of complexity, especially given today, our budget, we just paid out something like $2 trillion that we really didn't think that we were going to be paying for. And the government and all programs are going to be really having to look to see where are we going to get our budget? How are we going to pay for all these services that we promised to pay for? And that might be that taxes could increase in the future. So maybe deferring the tax could be a scary thing. It could be something that we have to be very meticulous about planning for. Life insurance, we don't. It's literally just cash. So that's why I think it's a good idea to start thinking early because you can address a lot of these different considerations ahead of time. But the short answer, I think, is to direct the money, wherever the inheritance is coming from, whatever source, get it into something that's going to be protected appropriately for the needs of your particular family.
Okay, and we had a question in the chat, Scott, asking if that same concept of leaving your life insurance to the special needs trust would apply to something like your home. And she says, can a special needs trust be a co-owner of a house, just like you're sharing ownership with the house with, say, a sibling?
Okay, yeah, very, very good. Yes, the answer in brief is yes. You can make the trust the owner of a home. You can make the trust the owner or the partial owner of a home. So for instance, you have 2 children and you give half of the home to one child and half of the home to a special needs trust for the benefit of the other child. That's totally possible, but being possible and being advisable are different things. Each circumstance, of course, is going to be different. That might be a good idea. It might be a bad idea. I don't know, in your particular case, whoever was kind enough to write the question, I'm not sure. But a trust can own anything that's legal to own. If that's a partial interest in a stock or a home, that's fine. We just can't, to make a crazy example that we can all understand, you can't make the trust own cocaine, like a cocaine farm or meth lab or something. It's illegal, so we can't do that. But anything else that's legal for an individual to own, your trust can certainly own. The harder part, though, is to plan appropriately for it. Very commonly, we do see people leave a home to a special needs trust, and that's it. That's generally not a good idea because the home has other expenses, and if there is no liquidity, there's no cash to pay for those expenses, we're not going to be able to continue to manage that home. So the devils, unfortunately, are going to be in the detail, and what's possible and what's advisable may not be the exact same thing.
Okay, thank you. What are some of the financial needs we should anticipate? And recognizing that every child is different, every person is different, but some of the financial needs we should anticipate as our children move into adulthood and after we're gone, financial needs that we need to anticipate.
I've got somewhat of a strong opinion on this. What are the things that we really want to focus on planning for? I would say my top three would be healthcare, housing, and transportation. And I think all three of those are completely interrelated. If we don't have transportation, it doesn't matter what type of health insurance we have, we're not going to get to the care that we need to receive. And if we don't have a good place to be healthy, we don't have a home, doesn't matter what type of health insurance or coverage or services we're receiving, we're not going to have the opportunity to be healthy. And if we can't link those two together through transportation, no plan's going to work out. So I think what we need to plan for is continuity in healthcare. And that's to make sure that we always have some form of insurance, whether that is private insurance that we're able to pay for on the open market, or it's going to be public benefits through maybe the Medicaid or the Medicare program if eligible. Transportation is more of a thought. That is, how do we get the guardianship in place to coordinate all of these things, all of the services together? And housing. And housing doesn't necessarily mean you have to leave a home to your child. That is not the requirement. So I'm not trying to put pressure on anybody or make anybody feel guilty or any anxiety about it. It's just thinking, if I'm not going to leave a home, or if I can't leave a home because there's no other way to maintain it, what's the next level of security that I can have? Is it a day program? Is it going to be living with a sibling? And then really developing that plan. It's going to take years and years and years to get comfortable with that. It's not always going to be an immediate, here's the solution, here's the formula, and we plug in the ingredients and we're done. But I do think those are the three big concerns that we were going to want to make sure that we address.
Okay, thank you. We had a question about the Secure Act that's been recently passed. It says, what's the impact of the new Secure Act on financial planning for my adult child?
Okay, the Secure Act is an interesting piece of legislation. And remember, the Secure Act took place before COVID-19. So how long it's going to be around, I don't know. But essentially what the Secure Act was, it was designed to get money out of retirement accounts. The government wanted to make sure that they're going to get the taxes that are deferred on things like a traditional IRA or a 401k. The general rule with the Secure Act is that if you leave your IRA or retirement account to a beneficiary, they have to take it out over a 10-year period. They're not able to stretch it out over the duration of their lifetime. That accelerates the income tax payment, and it could bump a person's income bracket into the next bracket. So we end up paying a little bit higher percentage of the income tax. There are exceptions to this rule. One exception is if you leave the funds to a disabled child or to a trust for the disabled child. Then that individual can stretch out the IRA over the life expectancy of that child. So we still get the stretch benefit for that. You, I think, need to be very cautious to determine if that's a good idea or not, because as I said earlier, our government's probably going to be looking for income sources for who knows how long, decades probably, to come up with another $2 trillion to offset the budget shortfall that we're going to have for this year at least. And so deferring the tax could potentially mean that you're going to be paying a higher income tax rate in the future. Now, I don't know. I don't know what it's going to be. That is up to Congress and some future Congress. We don't know what it's going to be. But also remember that if you need flexibility, which is one of the most important things I think you should consider in your plan, whatever your plan is, be flexible because things will change unexpectedly. Be flexible. If you plan to just stretch out your IRA, the part that you're stretching, the part that you're unable to access, you're planning on not being able to use that. And that can be a fairly big concern if you need additional money. So make sure that you're flexible. So I've kind of gone off topic here with the Secure Act in talking about the planning implications that it may have. So in brief, the Secure Act is designed to shorten the amount of time that you have to pay the tax on your IRAs. The exception is you can stretch it over the course of an individual who has disabilities. You can stretch it out over their lifetime, but you still have to plan appropriately for it.
Okay, thank you. Scott, the next question is about wills. Our question was, when do you suggest writing a will, and what important things should be included of the wills of parents of special needs, children and adults?
Okay, excellent. And thanks for all these questions. I think they're so well thought out and so important. So thank you all for your really thoughtful questions. Here's my attempt at bad humor, I guess. When do I suggest making a will? Every single day. I suggest it to every client that I have. Sorry, I know, bad joke, but you can't make a will until you're 18. So I do suggest that people who are 18 consider whether a will is appropriate for them. What a will does is it speaks on behalf of a person who is now deceased. The will explains to the world what the decedent would have wanted to happen with their estate, with their assets. Not everybody needs a will. If you don't have assets and you're perfectly comfortable with the estate going to your closest living relatives, you don't necessarily need a will. Your estate will go to those individuals. We have a law called intestate succession, where the government has already put into a formula or a recipe who's going to get that money. So if you're fine with what that plan is, then you don't need to make a will. However, if you do have assets and you do have beneficiaries who maybe need a little bit more protection than just an outright check to them, then you would want to seriously consider doing some additional planning. Now, your will is going to go through probate if your assets exceed the value of $100,000 or if you own real property regardless of its value. If you want to avoid the probate process, a trust is probably a better option for you. It's not your only option, but it's probably better than a will. But if you do have a trust or any of the will substitutes, that doesn't mean you should not make a will. Even for clients who are making revocable trusts or irrevocable trusts or special needs trusts, I still usually recommend that they make a will for a couple of reasons. Number one, you might pass away with assets that are outside of your trust. Maybe this is an insurance payment, it could be a lawsuit that was pending, or it could be an uncashed check. It could be very simple. We need a mechanism to get that asset into your trust, and we use a will to do that. The second reason why I like to have a will, even if I'm trying to avoid probate or ever looking at a will again, is to do what's called a testamentary nomination. This is a provision in your will where you're designating who you would like to be the guardian for your minor children or any child that might be under a disability. Oftentimes, if I'm looking at for example, a form off the internet, they're going to have a provision that says who you want to be the guardian for a minor child. They don't always say who you want to be the guardian for a child who's an adult but who is under a disability. As a parent, you can plan for that even after your child reaches the age of 18 or 30 or 50 or whatever. So that's a very important part of your plan, because even if you have a trust, if there is no guardian to be able to tell the trustee what the beneficiary needs, the trustee's handcuffed. They have no option. They have no way of knowing or deciding what your beneficiary needs. So in a quick summary, make a will to direct your assets to the right place. That could be your trust, and to designate beneficiaries for minor and children who might be under a disability. And you can start doing that at age 18.
Do you have to have legal guardianship of your adult child in order to designate guardianship after you've left? You know, someone who's taking care of your child after you're gone? Or can I designate that even if I'm not legal guardian of my adult child?
You can designate a guardian, you can nominate a guardian in your will, even if you're not currently the guardian for your child. The court, the statutes for guardianship give a list of priorities. Priorities are the people that the court has to evaluate to determine who should be the guardian. And first they'll look at spouses or adult children, then they'll look at parents and adult siblings. That's generally how the order of priority will work. So even if you're not currently the guardian, your will is going to speak for you when you pass away, and we can present that to the judge and say, look, mom and dad, who knew this individual better than anybody else in the world, wanted person A to be the guardian. And that's going to really be very helpful in your proceeding, because the court's going to relax a little bit and say, yes, this has been vetted by more than just this attorney, and I'm not looking at it for the first time. Other people have been planning this for a while. It's very helpful to have.
Okay, thank you. Scott, we really appreciate your help. I know someone told me you may have another meeting after this, and so that's all the questions we have for you. I've got a few for Susan. We would love for you to stay on, but if you need to pop off, we completely understand. We appreciate your expertise, so thank you.
Okay, well, thank you very much. I think I can stay on for a few more minutes just in case anything comes up, and I'd like to hear a little bit about what Ms. Rocco has to say, but thank you. I might have to jump off a little bit early, but for now, thank you very much.
Thank you, Scott. We appreciate it. And then I'm going to turn it over to Susan. Susan Rocco is, as I said earlier, a parent who has gone through this process, and in the course of her, I'll let her tell her whole story, but in the course of going through it, she researched guardianship, she knows her child, and she went a different route. And so we wanted to offer you in this informational session, not just information about guardianship, but about alternatives to guardianship. And so Susan, I'll let you start. Can you tell us about some of the alternatives to guardianship?
I can. Am I loud enough for you, Paula?
You're fine. Thank you, Susan.
And Scott, please call me Susan. Scott is a golden asset that we have used at our SPIN conference. He's very generous with his time, and we really do appreciate you. So thank you. So in order to know who I am, you probably need to know who Jason is. And Jason is my 39-year-old son, who is considered to be significantly disabled. He's not a talker. He expresses choice, but you have to really know him well to know exactly what that choice is. He lives at home with me. He has significant medical needs. And I have to give Jason credit for getting me my job at SPIN 35 years ago. You had to be a parent of a kid with a disability to apply, and here I am. So I'm still at SPIN. I'm the original spinster, and I credit Jason with all of my work, because all of us parents here on this broadcast know that we do what we do because we have our kids in our heart and in our mind, and we worry so much about what's going to happen to them when we're not around. I'm a single parent. I have been for about 33 years. I have an older brother who is disabled that I take care of. I have no other relatives on island except for an uncle who needs my attention too. So it's tricky when you think about what if, to come up with the right solution. And I just encourage all of you to read and to talk to other parents. And you may not get a bolt of lightning that says, aha, this is the answer, but you will start to see that one answer is less gray than the other. You will see some benefits on one side that are greater than on the other. And that's how we generally make decisions. So about the time that Jason was coming of age, I was working in the disability field, and we were in the era of self-determination. And I know that Scott believes in his heart that guardianship does not take rights away, but that's a different message than many people in the disability community have. And it's something that you need to be aware of, and you need to judge for yourself. If we have a benevolent guardian, all is well. If we don't, kids can really suffer. And if you as their parent or their guardian and you die and someone else becomes a guardian, you have to worry that that person has their best interest at heart. Because once a person is considered legally incapacitated, it's quite difficult to get the court to reverse that decision. It can happen, but it's difficult. So all of the things that were in my head at the time that Jason was getting close to age 18 was he going to go live in an ARC home? Was he going to live away from home? Because they were, at the time, they were requiring parents to get guardianship of their children to make their life easier as caretakers of their kids in a residential setting. But Jason is a kiddo that doesn't want to leave home. At least that's how I interpret his needs. He's a kid who's, this is a little risque, but I think you parents can appreciate it. We have a jacuzzi in the backyard that is his sexual partner, and he would never leave willingly. So this house is his home. He's so attached to it that the only kind thing for me to do would be for me to move out, and that's not really going to happen. So we have a happy household, even though I'm 70 and he's 39 and my brother is 72. It's whatever works for you. So having him under my roof made it a lot simpler in some ways. Then I found out about surrogate decision making, because I mentioned earlier that healthcare is a big issue for us and has been since Jason was born. And he has significant medical issues that sometimes send us to the emergency room, sometimes send us into the hospital. And he has about 4 specialists that work with him in addition to his primary physician. But what I learned through the UH Elder Law Program, and I know Paula has that reference and can link it in the handouts for you. They have come out with some really good guidance that they intended for older folks like me, but which also work for people with disabilities, who are also seen as folks who may not be able to make the best decisions for themselves. So what they taught me was that Hawaii has a law called the Uniform Health Care Act that says if an adult is, and this could be a person who becomes incapacitated, or like Jason, who's grown up kind of unable to make informed decisions, but it allows for the appointment of a surrogate decision maker who can then make all medical decisions for him except for end of care. I cannot tell the emergency room to take all the equipment away from him. But we have put together a post, which is his healthcare decision up front, that would tell them that, so I wouldn't have to intervene. But in my case, again, it was so simple because Jason's dad lives in Texas. He's rarely here. There's nobody else fighting to be Jason's guardian. All I had to do really was talk it over with his physicians, who had already been giving me all the power to make decisions. And once I signed that form, I can produce it for insurance companies. I can produce it for new physicians that don't understand it. It basically says that I have the right to sign his HIPAA forms, to sign him in and out of the hospital. So that was a big thing off my chest as well. and it didn't require guardianship. When Jason was in school, I believed in getting along. Now, those of you that know me may not believe that, but I knew that due process was going to make enemies out of my people at school that were going to be responsible for caring for Jason. So I did everything that I could to keep the relationship alive. Pete Wright, another attorney, says, if you're not going to pull your kid out of school and go to private school, then treat the relationship with school as a marriage without the possibility of divorce. In other words, you got to find a way to make it work. And I did. And after Jason turned 18, they did not argue when I went to the IEP meetings and I laid out what I wanted for him. But a big bolt of lightning came to me when I talked to a parent who, after her son turned 18, wanted to go to due process. And she was told flatly, you're not allowed to, you're not, your son is his own person after age 18. You don't have legal guardianship. And at the time, Hawaii didn't have any other options open to parents other than guardianship. Because of that, parent advocates, when we were revising Chapter 60, we made sure that there were some alternatives to guardianship for those parents like myself who are not ready to go the guardianship route. And so you can be an educational power of attorney for your kiddo, or you can be an educational representative. And I know Paula has links to that material. In fact, Debbie Kobayakawa was talking about it in an earlier session, I think. But those are tools that parents can use to continue to advocate under IDEA. So that's another check mark that did not require guardianship. I decided to open a small business for Jason because he really was considered unemployable by Voc Rehab. They said as much to us. Volunteer work was difficult. So I created a tiny little micro business, making Jason and I the owners of it. It's just little candles and soaps. And the first hurdle came when I turned in his very first tax form, because he can't sign his name. And I thought, oh Lord. So I called up the IRS and I said, what do I do? And they said, well, you should get guardianship. And I said, no. I found out there's an alternative, and that is Jason makes an X and I witness it and another person witnesses it. And the IRS takes his money just like they do everybody else, even though it's a tiny amount of money. So all of these things made it possible. Now, when we come to finances, Jason was initially ineligible for SSI because his dad was giving us child support payments that put us over the limit. But we put that money into an over 93 trust, and we can talk about that at another time. But it is one of those payback trusts that I can pull from it while I need it. But should Jason pass away, any money in that trust goes back to the government to pay for benefits. After I did that, he was eligible for SSI. And then when his dad retired, he got SSDI, which is a big jump in money, thank goodness. And after 2 years, you get Medicare with that. So now Jason has an over 93 trust income, and he has SSDI. Now, how do we handle that? We do it by making me his representative payee on his bank account. And it's really necessary in order to justify Jason receiving funds. If he were capable of spending money freely and wisely, he wouldn't need the funds, and he wouldn't need a rep payee to help manage those funds. So on all those counts, we've been able to avoid guardianship. And I know that for many families, the issue is monetary. You know, $3,000 to $10,000 is a lot of money. And for me, another disincentive was reporting to the court. You have to do that annually. And again, I worried about the succession issue. So these are all things that families have to think about. I am somewhat concerned that the schools often will tell a parent when their child is about to turn 18, if they're going to continue on in school, you have to get guardianship. And you don't have to get guardianship. And I think that they're misinformed. They're trying to be helpful to you, but that's not accurate information. I recommend that those of you who have some leisure read through a document that Paula has access to. It's called Beyond Guardianship Toward Alternatives That Promote Greater Self-Determination. And it's put together by the National Council on Disability, and it was put out in March 2018. They give you a history of guardianship and alternatives, which we have really discussed pretty significantly. I think the biggest alternative to guardianship is a circle of support around your kiddo. And that means not just you, but any friends. In my case, I do have a special needs trust for Jason, and my trustee is his caregiver from Bayada. And that sounds really weird, but that man has become like a second son to me, and he's stuck with us for 15 years. And who else is better able to take care of Jason? So these things get sorted out over time, but anybody that gravitates to your kid and likes your kid, you glom onto them and make them part of the circle of support, because at some point in their life, they can be a significant supporter. So I have gone on a monologue, Paula. I'm going to stop and let you finish up. But thank you for listening to me.
We appreciate the information, Susan. It makes me think. I taught special education for about 20 years, and sometimes I would have a parent come in and say, well, we want this exact thing because our friend's child has this in their IEP. And I would say to the parent, you know, an IEP should be about your child. It's an individual. Every child is different. Just because someone else does this doesn't mean your child does it. We do what's best for your child. And that's what this conversation reminds me of. I think that it's really good to know all the alternatives. For some families, guardianship is a really good fit. For some families, the surrogate decision making or POA, you know, there's lots of fits. And so I would encourage you to talk to your friends, talk to attorneys, talk to advocates, talk to your child, you know, and find out what is best for your family. But instead of just jumping off of a cliff, and don't write off one thing or another just arbitrarily. Because as we've seen, some people in this group, guardianship is a really good fit for their family. For Susan, this is a really good fit for her family. So I would encourage you to just keep an open mind. And I will be sending out all of this information, plus some links to some things Scott talked about earlier, including Social Security, disability. We'll have some informational links that we'll include in the follow-up email for that. I do want to share with you, I got an email kind of randomly just this weekend from someone named Kurt who works for Special Needs Hawaii, who says that they do offer no cost consultations for financial planning for parents of children with disabilities. And I will attach that website. I can't endorse it because I don't know anything about it, but they are local, and that is something that they say that they do. So I wanted to throw it out there. Our time is up, so I do want to thank Susan and Scott very much for answering our questions. This is a huge minefield of a subject, and as a parent, it's hard enough to contemplate just adulthood, much less adulthood when we're no longer there to help. And so this information is vital and appreciated. So thank you so much for your time. I do want to just invite you really quickly before we leave to register for our Talk Story session. That's on Friday. You can register through Facebook, or an email will go out tomorrow, and that's just a social group for people with autism and other disabilities. I see a lot of people who join us for that on this call, and the kids have a really good time. They've gotten to be a little group of friends through Zoom, and so that's a fun opportunity for them. So I encourage you to join us. And then on Monday, we co-host with Taka Coffee Talk, which is a parent support group. And you can register for that on TACA's website, TACA Hawaii, and I encourage you to sign up for that as well. That's a really great support system for parents. So again, thank you very much. Thank you again to Scott and Susan. And stay well, everybody, and hope to see you soon. Bye-bye.